This is Austin Smallwood, your SCR Director of Legal and Regulatory Affairs, to go over the upcoming changes to SCR Form 504. This is the buyer sale contingency addendum. The purpose of this form is if a buyer needs to sell their current home in order to purchase a new home, they will use this form and attach it to the contract. The changes to this form will be highlighted in yellow. Do note, though, however, when the form goes live, that those highlights will not be there anymore, so do take note of where the changes have occurred. The first thing happened is in paragraph 1, there used to be a number of boxes asking the buyer to describe the property. We sort of reworked that section. So now the buyer will put in their property address. That is going to be the address of their current property. So not the address of the house they were looking to buy, but the house that they currently own. Next, they're going to let you know, hey, is that property under contract or not? And if so, is a ratified redacted copy of the contract attached? If you're going to redact a copy of the contract, again, make sure that you're not including anything that is not absolutely necessary. Err on the side of redacting. If you have any questions on redactions, give us a call on the legal hotline or refer your client to their attorney. This is where you will use that SCR Form 500 to deliver notice that your property is under contract if the buyer's property is actually under contract. Next, you'll put when the property was listed, if it was listed by a particular brokerage firm, and whether or not that is listed on the MLS. That is so the seller gets sort of a better idea of how much marketing is being done on the particular property. This next section is really important. So previously we sort of had a date that you signed this, and then we had a buyer's sales deadline, and there was sort of nothing in between. So we would have the example on the hotline where you went under contract, April 1st, and your buyer's sale deadline was May 30th. But hey, May 25th, you still aren't under contract for your house. So everyone knows that buyer's not going to meet that buyer sale contingency. Isn't there some way that the parties can get out sooner? So that's where this pops up. So the buyer's property must be under contract no later than a certain date. And if it is, the buyer has to deliver in writing to the seller a copy of that Form 500 within 48 hours of ratification of that contract. If the buyer's property is not under contract by this date, then either party may terminate this contract by notice using SCR Form 313. This will have no effect on earnest money, as earnest money still needs to be dispersed only through mutual agreement of parties or a court order, but this will allow either party to terminate this contract by notice. Then we go to the second section. This is where the buyer sale deadline is. So this says that this contract, meaning the contract for the new house, is contingent on the marketing and closing of the sale of buyer's property, so the buyer's current home, no later than a certain date. And then within so many days of the closing, the seller and broker will be notified that the property is actually closed. If the buyer does not close by this date, then the buyer can terminate the contract by delivering notice using Form 313. If the contract on the buyer's property is terminated, though, however, so the buyer has met their conditions in paragraph 1, so they were still under contract by this date, but prior to the buyer's sales deadline, the contract fell through, then either party can deliver notice through 313 that they intend to terminate the contract. Now, should the buyer's property not close by the buyer's sales deadline, then the seller can terminate the contract by delivering notice unless the buyer can do one of two things. They can either show you, hey, I've got cash on hand and I can purchase, or I actually don't, my financing contingency is not contingent on me selling my house. I can essentially afford 2 mortgages. If the buyer is able to prove one of those two things, the seller cannot terminate the contract. If the buyer is not able to prove those things, then the buyer may terminate the contract if the buyer sales deadline is not met. And of course, if the buyer refuses to or fails to meet any of these deadlines, then either party can terminate this contract by delivering notice. The proper form for that is SCR Form 313. So what are the buyer's duties under this form? The buyer actually has to try to sell their house. They have to make good faith efforts. They need to timely inform the seller and their brokers of pertinent information regarding the sale of their property, and they need to direct their brokers and law firms to disclose pertinent information about their property. Essentially, the buyer needs to cooperate and actually show that they're trying to sell their home. If the buyer defaults on any of these duties, then the seller can, of course, seek their remedies, refer them to counsel. So paragraph 4 is sort of the guts of this form. This is where 504 really has its teeth, so to speak. This is where it will say that the seller can continue to market their property and can accept any offers of backup contract using SCR Form 391. There is a backup clause at the bottom of page 1 of that form. Make sure if you are submitting a backup contract that you are using on that clause in Form 391. So the first change that was made to paragraph 4 is no longer the seller delivering notice of a backup offer. They now actually have to deliver that they notice that they've accepted a backup contract. By the seller accepting a backup contract, they will now put the buyer on the clock for a few options. Those will be done through 505, but they are listed out here. So essentially, once the seller has accepted a backup contract, the buyer now has 4 options. The first is they can deliver SCR Form 500 showing that, hey, our buyer's, my property, my current house, is under contract to close by the date in this buyer sales deadline, and the only contingency we're waiting on is financing, because under the SCR contract, financing contingency runs through closing. The second option is, hey, I'll remove this sale contingency because I don't need this to purchase a house. Either I've got cash or I can afford 2 mortgages. The third option is I'll actually swap places. So this backup contract can now become your primary, and I'll go and be the backup contract. Or D, the fourth option, hey, we tried to make this work. We're just not able to make this work. Here's SCR Form 313. I'm going to terminate this. If the buyer does timely respond through the first 2 options, then they remain the primary position, and that backup offer remains the backup offer. If they don't timely comply, then either party can terminate by delivering notice using Form 313. And again, with most of our forms that we've been updating, we've added 2 additional buyer lines and 2 additional seller lines. So there should be 4 for each party on this form. So this is the changes to SCR Form 504. If you have any questions on this form, or any other form in the SCR Forms library, give us a call on the legal hotline, 803-772-5206.